This video is chapter 4 on capacity and contests. Even if a will is executed with all formalities, it can still be set aside if it has not been made voluntarily. It can be involuntary because of either a lack of mental capacity or the actions of a third party may render it involuntary. In this video, we're going to discuss who has the burden to prove capacity and how that burden may shift. We will also compare a will contest in probate versus an action in restitution for relief by way of a constructive trust. However, we will spend most of our time defining capacity and understanding the various ways in which beneficiaries to a will can contest a will under an objection that's related to a lack of capacity. So let's begin. First, we're going to talk generally about the capacity needed to make a will. We will refer to this capacity either as general capacity or testamentary capacity. If you turn to page 264 of your textbook, you will find the restatement, section 8.1b, 2003 edition, and this is going to be statute that we use to define mental capacity or general capacity or testamentary capacity. It is a 4-part test. For the first part, the testator must be capable of knowing and understanding in a general way the nature and extent of their property. The second element is that the testator must be capable of knowing and understanding in a general way the natural objects of their bounty. And the third element is that the testator must understand that the disposition that they are making of their property. In other words, they need to understand that they are giving their property away at death to another person. And the fourth element is that the testator must also be capable of relating these elements, 1 through 3, together. In addition to this 4-part test, most jurisdictions require that the testator be over the age of 18. All right, so let's apply this 4-part test to the facts of the first case. If you turn to page 265 of your textbook, that'll bring you to the case we are discussing, and it's in Wright's estate. The facts of the case are as follows. Lorenzo White died with his wife having predeceased him. White left a will that gave his house to his daughter, Maud. So here's Lorenzo White. He gave his house to his daughter, Maud. Here's the house. Then he gave a plot of land in Salt Lake City to his other daughter, Marjorie. So Marjorie gets the land in Salt Lake City. Then he gave a list of friends and relatives $1 each. Finally, he gave his second home and the remaining estate to his friend Charlotte. Now, the procedural history of the case is that the trial court denied probate because witnesses testified that the testator was exhibiting odd behavior. And that odd behavior included that the testator ran out of the house only partially dressed, that they picked up silverware from the trash, that they picked up paper flowers from garbage and pinned them to rose bushes, that they suffered a head injury that the cousin says seemed to change him, that the testator would hold their breath and pretend to be dead to scare the neighbors, that the testator told their granddaughter that she was wearing too much makeup when she wasn't wearing any at all, that the testator told people they had sent them a Christmas present when they indeed had not. So the issue presented before the court was whether or not this eccentric behavior was enough to prove a lack of testamentary capacity. This decision was rendered by the California Supreme Court, and the court said no. Their reasoning was that this eccentric behavior was not sufficient to show lack of capacity. Applying a rule similar to the restatement rule, they found that the testator understood the nature and extent of their property, that they understood their objects enough to list them out, and that they understood that they were disposing of their property and how they were doing it. So their eccentric behavior was not sufficient to show lack of capacity. This case demonstrates that irrational behavior is not sufficient. Wright knew he was making his will. He formed a coherent estate plan, suggesting that he knew what he owned. In that, he satisfied the test for testamentary capacity. So don't be fooled by facts that demonstrate simply eccentric or odd behavior. Now, before we go any further, I'd like to discuss the difference between the way in which contract law interprets capacity versus the way we interpret it in wills and trusts. You may remember the test for capacity from contract law. Be careful not to confuse it with capacity. Be careful not to confuse the capacity to contract with testamentary capacity. The standard for testamentary capacity is easier to meet. It is a lower bar, particularly as it applies to persons who may generally have issues with cognition or memory, or who have bouts of psychosis. If you take a look at page 269 of your textbook, you will see the rule for what are called lucid intervals. And this rule comes from a comment on the third restatement of property. It says that a person who is mentally incapacitated may still make a valid will, so long as that will was created during what is called a lucid interval. During that lucid interval, the testator must meet the four-part test for testamentary capacity. So as long as they're able to meet that same four-part test that we reviewed before, then despite the fact that they may be mentally incapacitated most of the time, as long as they drafted their will during that lucid interval, then the will be valid. Okay, let's take a look at a case that applies the lucid interval rule. And that case is Wilson v. Lane, and it is on page 270 of your textbook. This case also demonstrates who has the burden in a will contest to prove testamentary capacity. Now, I want to note, for the purposes of this class, you don't have to worry about understanding the complicated procedural posture of this case. So let's just turn to the facts. Greer executed a will in 1997, and in that will, Greer left his property to 17 beneficiaries, one of whom was Lane. The other 16 were family members. Greer also appointed Lane as executor of the will. Lane was Greer's caretaker. In 2000, Greer died. Lane offered up the will for probate, but Wilson, one of the 16 relatives, objected, arguing that Greer lacked the capacity. Friends, acquaintances, and Greer's attorneys testified that Greer's thinking was clear when they executed their will. The court felt that this was sufficient evidence. It was sufficient evidence to raise the presumption of testamentary capacity. Once there was a presumption of testamentary capacity, the burden then shifted, and the burden of proof was on the contestants to prove a lack of capacity. The evidence presented by the contestants fell in 4 different categories. In the first category, the contestants presented evidence that Greer exhibited some eccentric behaviors and beliefs. She, for example, had an irrational fear of flooding. She reported non-existent fires to the fire department. But as we learned in Wright, eccentric behavior is not enough to show lack of capacity. So let's move to the second category of evidence that the contestants introduced. The contestants introduced expert testimony that Greer had Alzheimer's, but the court found that the expert didn't explain how the Alzheimer's affected Greer's ability to form a rational desire to dispose of her property. So let's move to the third category of evidence. The contestants presented a letter from 1996 that came from Greer's doctor, and that letter said that Greer had senile dementia. But the doctor testified that he wrote Greer that letter to help her with a phone bill, and the doctor wasn't sure if Greer actually had amnesia. So the court did not find this evidence to be convincing. Moving on to the fourth category of evidence, the contestants presented a guardianship petition that was filed by Lane in 1988. But here again, the court was unconvinced because that guardianship petition was filed due to Greer's inability to live by herself, not because of any lack of mental capacity that she had. So given all of that, the court held that the evidence presented did not show that Greer lacked as they called it, a rational desire to dispose of her property. It's important to understand that the contestants have the burden of proof, and had the testator bore the burden of proof, then in this case the outcome may have been different, but that's not the case. Move on to the next case, In Stripma's estate. It's on page 274 of your textbook. This case has been included in your reading um, to show that societal context can influence the findings of mental capacity, and that gender bias has influenced and may continue to influence the outcome of some of these cases. This case also shows how insane delusions can affect the validity of a will. Here are the facts of the case. Louisa Stripmatter was an unmarried woman who left her estate to a feminist organization called the National Women's Party. She had been a member of the National Women's Party for 19 years. After Louisa died, some of her estranged cousins decided to contest the will on the grounds of insanity. Now, there was no question in regards to Louisa's competence. Her cousins argued instead that she had an insane delusion when it came to men. So again, to be clear here, the cousins did not argue that she lacked general capacity. Instead, they argued that she had an insane delusion, particularly when it came to men. So the issue before the court was twofold. The first was, did Stripmatter's hatred for men demonstrate insanity? And if it did that hatred then cause her disposition? In other words, did it cause her to leave her estate to the National Women's Party? The court didn't explore whether Louisa's hatred was at all grounded in reality or in her lived experience. They just held that her hatred of men was irrational. The court then presumed that this delusion was caused by the bequest. Now, it's not uncommon for older cases like this one to presume causation when there's an insane delusion and when that insane delusion has been proven, as long as there is also an unnatural disposition. So those two factors, a proven insane delusion plus an unnatural disposition, would lead the court to find causation. Now, as you may have picked up, the gender bias heavily influenced the outcome of this case. And this case serves as a good lesson on how mental insanity can be used as a tool to further embed societal norms. As I previously mentioned, there is a difference between a contest to someone's general capacity and a contest that involves an insane delusion. Our next case, Breedon v. Stone, provides a good description of the difference between these two legal concepts. To avoid arrest for a hit and run, Spice Breedon killed himself and his dog. Prior to his suicide, he had been drinking and using cocaine and had been very intoxicated. When the police found his body, they also found a signed handwritten note that you can find in your textbook on page 276. The note said, "I want to give everything I have to Sidney Stone." In this note, Spice explicitly listed his property, houses, jewelry, stocks, bonds, clothes, etc. Now, this note revoked his previous will and codicil, not explicitly, but implicitly, because the terms of it conflicted with his previous will. Well, after Spice's death, Sidney probated the will, and Spice Breedon's family objected, citing general lack of capacity and citing insane delusions. The probate court found that the contestants had not proven lack of capacity by a preponderance of evidence, which was the standard in Colorado. In their analysis of the insane delusions claim, the probate court found that while Spice Breedon did have insane delusions, these insane delusions did not cause the disposition. They were unrelated delusions. This decision was appealed to the Colorado Supreme Court, where the contestants alleged that the probate court incorrectly merged the application of the rules for general capacity and insane delusions. Now remember, contestants can prove a lack of capacity by showing either that there is a lack of general testamentary capacity, right, so the general capacity, or by showing that the disposition was caused due to insane delusions. The court held that despite Breedon's intoxication, Breedon had general testamentary capacity because they named their property and they listed their property in the note that they wrote. And they even gave the address of the will's beneficiary in the will. So Spice had put Sidney's address into the note. The court also held that while Breedon had insane delusions, again, they agreed with the lower court that these delusions did not influence his testamentary dispositions. If you're still confusing general capacity and insane delusions, I suggest taking another look at Breedon v. Stone. We're going to go ahead and end this video here because it's a nice breaking point. We have covered thus far general testamentary capacity and contest due to insane delusions. And we're going to pick up with undue duress in our next video.